Okay, good afternoon. We are ready for session 5, which begins at 2:15. I want to point out that Professor Susan Pace Hamill from the University of Alabama is en route. She got caught up in unexpected traffic and will be arriving in the middle of this session, and I will probably whisk her down the aisle and we'll discreetly place her at the end of the table, and everything will be okay. Before I introduce our other panelist, actually, I'm not introducing the panelist, I'm introducing the person who's introducing our panelists. And this is one of our distinguished alumna, Miss Ashley Penhale, who is with the Alabama State Bar. So please join me in welcoming Miss Penhale.
Good afternoon. Like he said, my name is Ashley Penhale. I'm the Director of Programs at the Alabama State Bar. For those of you who don't know, the Bar is the sole agency responsible for licensing and regulating the practice of law in the state of Alabama, subject, of course, to the rules of the Alabama Supreme Court. It's a very important caveat. And the Bar exercises general control over the conduct of Alabama attorneys and works to improve access to justice and the administration of justice in Alabama. So it's my pleasure to be here this afternoon on behalf of the Bar to introduce our speakers. The first is J. Mills Thornton, who was a professor of history at the University of Michigan for 35 years prior to his retirement in 2010. He currently resides in Alabama and is the author of multiple books, including Dividing Lines, Municipal Politics, and the Struggle for Civil Rights in Montgomery, Birmingham, and Selma. He earned his PhD from Yale University in 1974, studying under C. Van Woodward, the leading scholar of Southern history and race relations at that time. Dr. Thornton is a nationally known expert on the subject of civil rights movement and local activism and Southern history during the period of 1815 to 1877. He has also received numerous awards, including a Guggenheim Memorial Foundation Fellowship. Our second speaker is Susan Pace Hamill, who has been a professor of law at the University of Alabama since 1994, teaching in areas of tax, business organizations, and ethics. She has published 3 books, 2 book chapters, 24 law review articles, and 25 essays and editorials in newspapers and magazines in both Alabama and throughout the country. During the first decade of the 21st century, her scholarship declaring the tax policies of Alabama and other states immoral earned a front-page story in the Wall Street Journal, feature stories in both the New York Times and the London Times, and extensive nationwide press coverage, including interviews on ABC, NBC, and NPR. She has done hundreds of speaking engagements in 28 states, and in 2010, she was a candidate for the Alabama State Legislature. In 2011, Professor Hamill's writings embarked in a new direction, a joint disciplinary effort with the English department, harnessing the power of literature to portray injustice embedded in the law. Her debut literary piece, a memoir about her campaign, Pretty Hair, Discovering the Grassroots on the Campaign Trail, is moving towards publication. Professor Hamill served pro bono as an expert witness, consultant, and authored an amicus brief for plaintiffs in 2 federal lawsuits challenging Alabama's property tax structure on race-based equal protection grounds. Professor Hamill is married, the mother of 2 adult children, and a member of the United Methodist Church. She holds an MTS from Beeson Divinity School at Samford University, an LLM from New York University School of Law, a JD from Tulane University School of Law, and a BA from Emory University. So let's welcome one of our 2 afternoon panelists, at least.
When Alabama's Constitutional Convention of 1819 met in Huntsville at the beginning of July, the infant state's economy was in the process of disintegrating. The return of peace to Europe in 1815, after a quarter century of war, had released enormous pent-up demand for textiles and other consumer goods. But by late 1818, that unusual demand had begun to be satisfied, and textile mills had started to moderate their output. In January 1819, as a result, the inflated price of cotton on the Liverpool Exchange suddenly collapsed, falling by 25% in a single trading day. The result was the Panic of 1819. Before the panic, cotton had been selling for 25 cents per pound. By the time the Constitutional Convention met, it was down to 12 cents and still falling. These events were far beyond the control of Alabamians, of course, but the territory's settlers and their political leaders had taken actions that vastly exacerbated the situation. The demand for cotton had been so strong that bidders on the lands that the federal government began offering for sale in the newly opened territory in 1817 and 1818 pushed prices up to inordinate levels. The result was an acute demand for credit. The first session of the new Territorial Assembly, meeting in St. Stephen's in February 1818, sought to meet this demand by repealing the Mississippi Territorial Act of 1805 that had limited interest rates on loans to 6%. Henceforth, though bank loans continued to be capped at 6%, all other loans could bear any rate that the contracting parties agreed to. Creditors very quickly began demanding extraordinary interest. At first 3% or 5% a month, then 10% a month, finally 20% a month. The author of this act repealing usury limits was Representative John W. Walker of Huntsville, the son-in-law of the president of the Huntsville Bank, Leroy Pope. Doubtless fearing that his motives might be impugned because of his familial relationship, however, Walker induced a close friend in the Assembly, Abner S. Lipscomb of St. Stephen's, to introduce the act. It was referred to a select committee consisting of Lipscomb, the bill's sponsor, Walker, its author, and Clement C. Clay, the Huntsville Bank's principal attorney. Reported favorably, it was passed by voice vote. These events would provide rich fodder to the enemies of the new state's capitalists once the act's effects became obvious. By the time the Constitutional Convention met in the summer of 1819, it was clear to all the delegates that as soon as Alabama could create state courts, they would at once be flooded with suits for collection of the many enormous outstanding debts. The debtors had counted on high cotton prices to service their loans, and now they could not do so. Creditors who had influence with the state's two small banks had borrowed large sums from them at 6% in order to lend the money out at vastly greater rates, and now the hard-pressed banks were demanding payment. The land purchasers had bid far more than their land was now worth, and the United States was expecting to get its money, threatening a great many of the state's new settlers with a return to the status of squatters. As Alabama's economy imploded, one of the most controversial questions before the Constitutional Convention was, therefore, the method of choosing state court judges. John W. Walker, the author of the repeal of the Usury Act, was now the convention's president, and Clement C. Clay, the Huntsville Bank's leading attorney, chaired the committee of 15 appointed to draft a document for the convention to debate. They were both men intent on insulating the state court judges from Alabama's increasingly volatile political climate. They therefore desired life terms during good behavior for the judges on the model of the federal Constitution, though with the judges elected by the legislature rather than nominated by the executive. Pro-debtor delegates, led by James Jackson of Watauga and Reuben Saffold of Clark, pressed, however, to limit judges to 6-year terms. In the end, the convention, with a majority friendly to capital and development, voted 26-18 for life terms. But the pro-debtor delegates managed to extract two concessions. The Constitution provided that the initial set of judges to be elected by the 1819 legislature would serve only until 1825, and the life terms would go into effect only for the judges chosen in 1825. And in addition to the impeachment provisions applicable to all officials, including judges, for criminal offenses, the Constitution provided that judges alone could also be removed for any cause, whether criminal or not, by an address adopted by a 2/3 vote of each house of the legislature. Just as the delegates on all sides had expected, as soon as the new state courts opened for business at the beginning of 1820, suits on the debt contracts poured in. A central figure in these proceedings was Huntsville attorney William Kelly. Kelly had come to Huntsville from Tennessee in 1818 and had formed a law partnership with fellow Tennessean Anderson Hutchinson. As creditors filed their numerous actions for collection, Kelly and Hutchinson quickly turned their practice almost exclusively to defending debtors. And beyond the courtroom, Kelly took to denouncing the creditors and the Huntsville Bank as representatives of the merciless hand of wealth and power seeking under the guise of law to grind its victims to dust. Very soon, many poorer Alabamians came to regard Kelly as their hero. And when John W. Walker, whom the first legislature had chosen to represent the new state in the U.S. Senate, died suddenly at the end of 1822, Kelly offered himself to fill Walker's unexpired term. Kelly's opponent in this election was another Huntsville lawyer equally prominent in the developing debt controversy, future U.S. Supreme Court Justice John McKinley, who had come to Alabama from Kentucky in 1819 and had very quickly become a favorite attorney of the creditors. Kelly was elected by a single vote, 39 to 38, and took his seat on January 21, 1823. Unquestionably, the single most radical senator Alabama has ever sent to Washington. In October of 1823, another Huntsville enemy of creditors, William B. Long, established a newspaper, the Huntsville Democrat, to champion Kelly's cause. Long christened Kelly's opponents the Royal Party, and his editorial fulminations urgently warned that their ultimate aim might well be to establish aristocracy in the Tennessee Valley. In the midst of these events, what had become known as the big interest cases approached their first appellate decision. At this time, the state's 6 circuit judges also constituted, sitting en banc, the state Supreme Court. At its June term of 1824, the Supreme Court ordered the numerous debt collection actions that had been making their way to it from around the state consolidated for hearing under the lead case of Henry and Winston versus Thompson. Senator Kelly and his law partner Anderson Hutchinson appeared for the debtors, and Clement C. Clay, principal attorney for the Huntsville Bank, and Henry Hitchcock, principal attorney for the Tom Beckby Bank of St. Stephen's, and also the state's attorney general, argued for the creditors. Kelly, in his oral argument, admitted that he could cite no precedent for the courts not enforcing the contracts, but he said that judicial remedies must of necessity keep pace with fraudulent ingenuity, and if the contracts will bankrupt the country, it is surely time that a new precedent should be made which will put a stop to the work of ruin. The majority of the court proved surprisingly open to this novel claim. By a vote of 4-2, Kelly managed to enlist the state Supreme Court as unlikely allies in his crusade. The majority held that once a note had matured, interest on it became unspecified, and so was limited by the 1818 Act to 8%. But Kelly also, by this decision, made the banks and creditors his implacable enemies. When he sought election to a full Senate term in his own right, the Huntsville Bank and its allies put up against him a member of the bank's board of directors, Huntsville physician Henry Chambers, and Dr. Chambers defeated Kelly 41-36. Kelly, however, was unchastened. When he left the Senate in March 1825, he announced his candidacy for the state legislature, and when the legislature met that fall, he was chosen Speaker of the House. This was the session at which the legislature was to elect the judges for life terms. Kelly and his associates succeeded in defeating Henry Manor, one of the two justices who had strongly affirmed the validity of the big interest contracts, after a lengthy contest of 7 ballots, and replacing him with John M. Taylor, who had been bankrupted by the panic and who could therefore be counted on to sympathize with the debtors. And at this time, thoroughly satisfied with the state's judiciary in the light of his Henry and Winston triumph, Kelly opposed a constitutional amendment to limit judges' terms to 6 years, which failed for lack of the required 2/3 vote. Kelly was defeated for re-election to the legislature in 1826, but he pressed ahead with his judicial assault on the creditors. The Supreme Court, having ruled in Henry and Winston that any payments beyond 8% collected on the big interest contracts was illegal, Kelly and Hutchinson stood to recover huge sums for those debtors who had paid them, and of course for themselves also as contingency fees. But they faced a problem. The first action of the first legislature had been to repeal the Territorial Act eliminating the usury limits. And so these contracts were now rapidly fading into the past. The state statute of limitations required that any writ of error appealing a judgment of circuit court had to be filed within 3 years of the judgment. But the Henry and Winston decision had not come down until June 1824. By that time, the possibility of appealing circuit court decisions entered in the suits that had flooded the courts in the early years had expired, and many of the debtors had accepted the judgments and sold their property to pay. Many others, acting under what turned out to be erroneous legal advice that the contracts were binding, had paid without any court actions at all. Kelly and Hutchinson sought to get around this situation by filing bills in chancery, arguing that although the law courts were now powerless to help the debtors who had not appealed, the chancery courts could intervene to remedy the manifest injustice of their having been forced to pay interest subsequently established as illegal. The state Supreme Court consolidated 13 of these appeals under the lead case of Jones versus Watkins, and heard them at its July term of 1826, the second of the big interest cases. The arguments occupied 6 days. Kelly and Hutchinson, together with 2 colleagues, represented the debtors, and Clement C. Clay, John McKinley, and future Whig champion Arthur F. Hopkins appeared for the creditors. At the conclusion of the week of arguments, the court took the cases under advisement. On January 8, 1827, the decision was finally announced, and it represented a thorough defeat for Kelly and his colleagues. Only Justice John Gale, the court's most unwavering defender of debtors, accepted Kelly's and Hutchinson's arguments, and he dissented without an opinion. The other 4 justices were unanimous in concluding that the arguments were without merit. It appeared at first glance, then, that the arguments of Kelly and Hutchinson had been rejected 4-1. And that is what most observers concluded. But a closer examination reveals that the 4-judge majority was itself evenly divided, with 2 justices, Abner Lipscomb and Reuben Saffold, adhering to the Henry and Winston precedent, but rejecting the possibility of equity relief, while the other 2 justices, Anderson Crenshaw and John White, also rejected equity relief, but went on to reject the underlying Henry and Winston decision itself. Kelly had labored long in 1825 to defeat Henry Manor for re-election, only to find now that the new judge, John White, agreed with Henry Manor's dissent in every particular. The division in the Jones versus Watkins majority would play a crucial role in the unfolding drama's final act. For the present, Kelly responded to his defeat by again announcing for the legislature. He was elected, and when the legislature met that fall, he threw himself into obtaining the passage of the constitutional amendment that he had opposed in 1825 to limit judges' terms to 6 years. He and his allies succeeded in getting a version of this amendment submitted to the voters. An unexpected event during this session, however, became central to Kelly's subsequent actions. Shortly after the legislature convened, Speaker Samuel W. Oliver laid before the House a letter from Attorney George F. Salley charging Chief Justice Lipscomb with corruption and malpractice in office. Oliver then appointed Kelly to a 5-member select committee to investigate the charges. The complaint, as it turned out, derived from the recent suspension of specie payment by the Tom Beckby Bank. The Tom Beckby Bank was deeply embedded in state politics. Its president, William Crawford, was also concurrently Alabama's only U.S. district judge. Its principal attorney, Henry Hitchcock, was concurrently the state's attorney general. And Chief Justice Lipscomb, who served as the circuit judge for the St. Stephen's area, had been the territorial legislator who had sponsored the bank's charter and had served as one of its incorporators. Its suspension had caused widespread dislocations and hostility in South Alabama. State Representative Erasmus Walker of Selma railed that Judge Crawford's conduct before the suspension had been a procedure never countenanced by the Huntsville Bank in its days of deepest peculation and fraud. Kelly supported Walker's charges and offered a memorial asking Congress to authorize a second district judge for the state. Sally's specific charge concerned one of the litigants involved in the Tom Beckby Bank suits, Samuel H. DeWolf, who had taken to denouncing Judge Lipscomb in court and out as a tool of the bank. As a result, Lipscomb had jailed DeWolf on 4 separate occasions for contempt. After 2 days of debate, the House concluded that Judge Lipscomb had acted honestly and did not deserve censure. The matter was formally resolved on January 1st, 1828, and only days later, Kelly was again before the Supreme Court to argue another, at the time little noticed, big interest case, Thompson versus Jones. Kelly appeared for the debtor Jones and was opposed by Senator John McKinley and Arthur F. Hopkins for the creditor Thompson. Robert Thompson was the Tennessee Valley capitalist behind many of the big interest contracts. He had been the defendant in error in Henry and Winston versus Thompson, and the original note underlying this new case was typical of his extortionate demands. The principal of the note was $4,400, but it bore interest at $10,000 a year, 20% a month. To save his friends from bankruptcy, Little Barry H. Jones had agreed in March 1822 to take up their note and give Thompson a new one to secure it. Thompson claimed that Jones had accepted the terms of the original big interest contract and insisted, despite the Henry and Winston decision, that under the terms of the 1818 Act repealing usury limits, the contract's rates were valid. Jones replied that if his note of 1822 did incorporate the rates of the original note, then under the Usury Act of 1818 that had replaced the 1819 that had replaced the 1818 Act, the terms were usurious and the entire contract was void. Judge John Gale, the judiciary's most persistent champion of debtors, presided as circuit judge and gave judgment for Jones, from which Thompson appealed. The outcome of the appeal revealed the unresolved divisions among the justices. Chief Justice Lipscomb and Justice John M. Taylor, whom Kelly's efforts had placed on the bench, agreed with Judge Gale's ruling that the note was usurious and void and wanted to affirm. Justices Anderson, Crenshaw, and John White, who believed that Henry and Winston had been wrongly decided, therefore insisted that the original note was valid and Jones owed the full amount. They wanted to reverse Judge Gale and remand the case with an order to fine for Thompson and compel full payment. That left Justice Reuben Saffold, whose conclusion was his alone, but because of this division, therefore controlled the case. He believed that Jones was indeed responsible for the terms of the original note, but that under the Henry and Winston decision, Jones could only be charged 8%. Saffold wanted to remand the case so that Jones could be allowed to satisfy the judgment with this partial payment. Thus, the case was remanded 3-2, but with no clear guidance about what to do thereafter. When in September, Justice Saffold, now presiding as circuit judge at the remanded retrial of the case, granted Thompson's attorneys a continuance on what seemed to Kelly the absurdly false claim that they had not had sufficient time to prepare for trial, it was for Kelly the last straw. The entire proceedings in this case seemed to him to encapsulate the judicial tergiversations that were depriving debtors of the protection due them from courts of justice. He concluded that his great triumph in Henry and Winston was on the verge of being vitiated. His profound disappointment with the Jones versus Watkins decision and his rage at the behavior of the judges in Thompson versus Jones now came together in his mind with his involvement in George Sally's complaint against Chief Justice Lipscomb the preceding December to indicate to him how he should proceed. And so, when the legislature convened that November, Kelly submitted to the state Senate a lengthy letter indicting the conduct of Justices Saffold, Crenshaw, and White, and urging a legislative address to remove them from office. Though Kelly's outrage is clear from his letter, he found himself unable to separate his genuine desire to defend the rights of debtors from his sense of personal affront and his suspicion that he was a victim of a conspiracy. Kelly had never been hesitant about acknowledging his own pecuniary interest in the outcome of the big interest cases. He told the legislature, under a belief that the Supreme Court justices would abide by the principles settled and sanctioned by themselves in Henry and Winston, I made contracts that I could have complied with if they had met the expectation generated by their own decision, but which I had no means to meet when they departed from their decision and dismissed my cases in Jones versus Watkins. Nay, I was, by that unexpected event, plunged into a state of embarrassment little short of hopeless, irretrievable ruin. But he had come increasingly to feel that at least some of the justices were allied with his political enemies in a plot against him. He wailed that my professional disappointments have been afflicting in their character and blasting in their extent. I have struggled with oppression, merciless and insatiable in its character, and have struggled in vain. The judges have given it the sanction of their authority. He then launched into a catalog of cases that he believed had been decided against him on clearly inconsistent principles. Nothing linked the cases except that he was the attorney in them, which seemed to mark me as the medium of misfortune to my clients, he wrote with his typical sense of persecution. To see the justice of my country thus mangled and mutilated excited feelings that it is painful to remember, difficult to describe, and impossible to forget. If the justices had been aware, equally as problematic as these elements of Kelly's letter was his inclusion of Reuben Saffold among the justices he indicted. From the time of the Constitutional Convention of 1819, Saffold had been openly sympathetic to the debtor's cause. Kelly himself in his letter noted that Saffold's general qualifications for the discharge of his official duties are respectable, and his conduct generally as a minister of justice has been unobjectionable and satisfactory to the profession and the community. The essence of Kelly's charge against Saffold was that through his maneuvers in Thompson versus Jones, the vanity of Judge Saffold seeks to be tickled in enforcing his own opinion upon the court by the influence of circumstances leading to acquiescence, when in fact not a single judge really agreed with him throughout. Could his honor have been seduced by the pride of opinion? This amounted really to the charge that Saffold had not agreed with Justices Lipscomb and Taylor, as Kelly thought he should have. When Kelly turned to Justices Crenshaw and White, however, his arguments at last moved to somewhat firmer ground. He noted quite correctly that both men completely refused to accept the authority of the Henry and Winston precedent and proceeded to decide cases as if it did not exist. And he continued to attempt to define the differences between their understanding of justice and his own. Their frigid, sophistical conceptions of the rules of law and canons of property have led them so far astray from plain, palpable justice, and their heartless disregard of its plainest dictates has given me a very humble opinion of their fitness for the bench. They are wretchedly deficient in aptitude for the dispatch of business. Putting aside his insults, Kelly was doubtless right in believing that Crenshaw and White did not share his passionate desire to see the courts become the defender of distressed Alabamians threatened with the oppression and exploitation of the wealthy. Justice Saffold replied by submitting a copy of his opinion in Thompson versus Jones and inviting the senators to read it for themselves. And he then said, almost certainly correctly, that what was behind Kelly's complaint was his bitter disappointment at the outcome of the second of the big interest cases, Jones versus Watkins. He noted the incessant obloquy against the judiciary with which the memorialist, that is Kelly, has endeavored to enlist the credulity of vulgar prejudices since the decision of the Supreme Court in January 1827. And Kelly's own admission of his pecuniary embarrassments and blighted hopes after it. And he added with obviously deep resentment, the coming ages in which Kelly seems to expect his memory to live will find nothing in a history of his deeds that has ever been admitted into the stock of any nation's glory. If Saffold was resentful, however, Justice Crenshaw, whom Kelly had called incompetent and unfit for office, was livid. He observed acidly that, assuredly, this is the first time that anyone has been found shameless enough to avow as a reason for the removal of a judge from office that he had been unsuccessful in the prosecution of suits he had commenced. As to Crenshaw's disagreement with the decision in Henry and Winston, if the Supreme Court has not the right to depart from the rules and principles of a decision once made when discovered to be erroneous, then error would be immortal and reason and argument unnecessary. Alluding to Kelly's wish that the courts would enlist in his crusade in behalf of debtors, Crenshaw responded, "It is a monstrous doctrine that courts of judicature should decide the rights of parties litigant by reference either to their affluent condition or their pecuniary wants. or should suffer their decisions to be controlled by the circumstance that they will be impoverished or enriched. Yet this is the doctrine directly maintained by the memorialist. The legal principles that Kelly called frigid and sophistical protect us from Kelly's own principles that would, in effect, enable the judge to create a law for each particular case and to measure out justice by the size of his conscience. And turning to Kelly's assertion that Crenshaw lacked any aptitude for the bench, what he lacked, Crenshaw said, was Kelly's own aptitude for slander and abuse. He had no capacity to stir up lawsuits, to excite litigation, to poison the peace and harmony of society, to build his hopes and make contracts on the expectation of realizing large contingent fees. And when disappointed by the operation of even-handed justice, he has no capacity to denounce the ministers of justice by preferring before this honorable body a memorial fraught with the deepest malice and falsehood, and clothed with sentiments and expressions which no mind could conceive and no tongue could utter, but that of a man driven to desperation and bent on his wicked purposes at all hazards. The Senate gave its Judiciary Committee subpoena power, and the committee proceeded to take testimony from many of the leading figures of the Alabama bar. It then submitted all these documents to the full Senate. On January 20th, 1829, the Senate heard Kelly in oral argument, and on January 21st, the attorneys retained by the three justices, John J. Ormond and Arthur F. Hopkins, replied, and Kelly offered a closing rebuttal. The Senate then debated the matter and voted. The vote was unanimous that the charges against Justice Saffold were not sustained by proof. But on the charges against Justices Crenshaw and White, the allegations were rejected 15 to 5, with 5 North Alabama senators allied with Kelly voting to accept them. In the meanwhile, the Senate had been grappling with the constitutional amendment that Kelly and his friends had pushed through the preceding session of the legislature to limit the terms of judges. This had been the first time that Alabama had held a referendum to ratify a constitutional amendment, and apparently some confusion had surrounded how to conduct it. Because the Constitution required the affirmative vote on the amendment of a majority of persons voting for state representative at the same election, a joint legislative committee reported that it could not determine if the constitutional requirement had been met. The legislature therefore voted to resubmit the amendment to another referendum. That summer it was ratified easily, carrying all counties except Tuscaloosa and the 3 Tennessee Valley counties of Madison, Limestone, and Franklin. In 1830, the amendment became a part of the Constitution. The imposition of 6-year terms on judges essentially made the constitutional device of removal by legislative address superfluous, and Kelly's memorial thus became the last attempt to use it. But his complaints and the heated debates that had surrounded them left consequences. In 1831, the year in which the unswervingly pro-debtor Judge John Gale was elected governor, the legislature passed a bill to create a separate state Supreme Court. The legislature then proceeded to choose its first 3 justices, electing the 3 judges most committed to the Henry and Winston decision, Abner Lipscomb, Reuben Saffold, and John M. Taylor. Anderson Crenshaw and John White were both left as circuit judges, now subject to firm appellate oversight. In the meantime, however, disgusted by the Senate's rejection of his memorial, and doubtless suspecting that thereafter he was highly unlikely to win many cases before the Supreme Court, William Kelly abandoned his Alabama career. In 1830, he moved to New Orleans, and there in 1834 he died. The final ironic result of Kelly's crusade was that the now more frequent judicial elections that his efforts had created produced such widespread hostility to the legislative vote swapping and log rolling that accompanied them that it led to a new constitutional amendment ratified in 1849 to turn the election of circuit and inferior court judges over to the people. Thank you.
It's good to see you again. Yeah. I want to apologize for my tardiness. The navigating my trip from Tuscaloosa to Montgomery, which is usually an hour if I take the back roads, or at most an hour and a half as I speed along in my 6-speed if I take the front roads, got kind of messed up. And it sort of reminded me of navigating the 1901 Constitution, which is what I'm going to talk about this afternoon. In the sense, I was stuck in a monsoon, constantly going 30 miles an hour, down to 15, occasionally up to 45 on the interstates. Then we stopped cold and couldn't move. And my crafty husband navigated me from an app and a map off 217 onto a back road to find Highway 31 south to get back on the interstate, of which I proceeded to go 90 miles an hour through Prattville and arrived to hear the tail end of Dr. Thornton's presentation. And I'm sorry I didn't get to hear it all, but some of the descriptions you gave of these characters, wicked, despicable, memorialists, giving false impressions, and moreover, fostering oppression of debtors and others in need, certainly would describe how the 1901 Constitution impedes tax reform. Now, before you yawn, I promise you that this will at least be as interesting as my most interesting honors college class, which is about the state of Alabama. I currently teach a class to undergraduates about the state of Alabama, and it's a really cool class. And Mills's name is mentioned in a few of the books I use, so my students are exposed a little bit to your work. But at any rate, I am a tax lawyer to the core. I went to NYU and got a tax LLM. I was brought to the University of Alabama Law School to teach tax law, as well as business organizations. And in the world of law, the Constitution isn't supposed to have anything to do with the details of taxation, other than if you have a situation where one state is trying to tax out-of-state businesses more than in-state businesses, which, by the way, is an Alabama tradition. Cases like that invoke Commerce Clause violations and do end up in the U.S. Supreme Court and are considered constitutional issues. But outside of what I'm going to call states poaching on other states to try to raise their revenues, the details of tax law is supposed to be a function of the legislative body, which would be our state legislature members, for better or for worse, by the way, or the local county commissions, the people who live in the local counties, the mayors and the city councils, and the people who live in the cities. That would be the local stuff. Now, in 2002, I did a big study of the Alabama state and local tax system and kind of deemed it immoral, and that's another story, but it did get me in a bit of trouble with the big timber lobby. And when I did this study, I concentrated on the details of how the taxes worked to essentially overtax the poorest Alabamians, and let the wealthier Alabamians off practically scot-free. And then Howard Walthall. I don't know, how many of you have heard of Professor Howard Walthall of the Cumberland Law School? Yeah, I mean, Howard has been around a long time. He's taught at Cumberland forever. He is a native Alabamian. He loves his state. And he's been involved in the study of and the attempts to reform the 1901 Constitution for probably for at least as long as I've been alive. And Howard and I are good friends. So Howard came up to me after I published this article about Alabama's taxes and how terrible they were and why they were so terrible. And Howard said, "Susan, I'm getting together a group of scholars to write law review articles for the Cumberland Law Review addressing the ways the 1901 Constitution needs to be reformed. And I want you to be my scholar writing the article about the 1901 Constitution and how it impedes tax reform." So I'm going to dedicate this little spiel to Howard. And of course, being rather arrogant back then, thinking I knew everything, I said, "Howard," I said, "taxes don't have that much to do with the Constitution." He said, "Well, I guess it'll be an easy project for you then. So just agree to do it." So I said, "Sure, Howard, anything for you." So I called the library and I asked one of the staffers, "Could you please bring me up a copy of the Alabama 1901 Constitution?" You can see I'd never seen it before. So the staffer comes up and says, "Here you are," and hands me this really fat book. And I didn't even look at it. I said, "I told you I wanted the Constitution, not the corporate code." And she said, "That is the Constitution." And I started flipping through it. There's no index. It's just amendment after amendment chronologically. There's no difference between amendments that affect statewide, amendments that affect local. And my heart started to sink and I realized that Howard had hoodwinked me. So I emailed him and told him this was halfway through it, the most miserable project I'd ever endeavored in my entire life. He said, "I'm glad you're enjoying your work and I look forward to your draft by your December 1 deadline. Thank you." So I'm just going to give you the highlights of what I discovered when I had to go through the Constitution, index it myself, by the way, and discover how it impedes tax reform and why. Well, let me just run through some very basic facts about our state and local taxes in the state of Alabama. They're the lowest revenues per capita in the nation. No small wonder why the schools are starving, and we're under the watch, really under the scrutiny of the Justice Department with our prisons, if you haven't read about that. And the schools are struggling, so our revenue situation is pretty bad. We impose the burden for paying our state and local taxes in an extremely regressive fashion. The bottom 20% of households bear a tax burden more than twice on a percentage basis than the top 1%. So why are we so regressive and why are we so inadequate? Well, you're about to find out. It's the 1901 Constitution. Little primer. We did a study and determined, okay, what Alabama taxes produce what portion of the revenues? Well, almost half of our tax revenues are from sales taxes. You go to the grocery store, in Tuscaloosa, it's 9%. So $100 worth of groceries costs $109. So it's no small wonder that we're regressive. Sales taxes are inherently regressive, and the more sales tax heavy a state is, the more regressive their overall tax structure is going to be. And we are very sales tax dependent. And not surprisingly, the Constitution imposes no limits on sales taxes. So this is the go-to place when there's emergency revenue needed, just jack it up another penny, which is what Walt Maddox tried to do recently in Tuscaloosa. And for the most part, he's a pretty good guy. Okay. What about the income tax? We rely on income taxes for about 22% of our revenue. And the answer is the 1901 Constitution has a lot to say about the income tax. The first income tax came in our state in 1933 because there was a huge revenue crisis, and at that moment, the exemptions from the income tax were enough to shield poverty income, and the rate was capped at 5%. This was anchored in the 1901 Constitution. So, in order to increase rates, you've got to amend the Constitution. Not pass it through the legislature, which is what we do in Congress, but amend the Constitution, which requires what? 2/3 of the House and Senate, and then it's got to go to a statewide vote, which of course is fraught with peril. Another piece of the income tax that's in the Constitution is a deduction for federal taxes paid, which means the more you pay Uncle Sam, the less you pay Alabama. Get the drift? Who benefits? That's anchored in the Constitution. In 2003, Governor Riley tried to get us on the road to income tax reform. His plan would have raised the rates on the wealthier Alabamians, of course, increase exemptions to stop taxing poverty level income, and would have gotten rid of that deduction for federal taxes paid. Well over half of all Alabamians would have experienced a tax cut in their income taxes, but Governor Riley's plan failed by a 2-to-1 margin because the fearmongers convinced low-income voters, especially low-income white voters, to vote against their own tax decrease. I'll never forget the morning after we lost. I got all of these phone calls from my buddies up north. And they said, how in the hell could you have lost a tax referendum when more than half of the voters would have gotten a tax cut? And I said, I have no idea. I'd better figure out why. That was a bad morning. But the worst is yet to come. The property tax. This is where it really gets sensitive. The original 1901 Constitution, and I'm sure you've gotten some historical background from other speakers. The original 1901 Constitution was a reaction against the Reconstruction era policies, which did involve property tax increases because we needed to educate a whole lot more free people, for example. It was a reaction against a populist uprising of white farmers that were tired of struggling. And it was a fraudulent document, ballot stuffed in the Black Belt to do a number of things. And I'm sure you've heard about, stripping the vote except for the propertied white elite. Yes. But the less known evil deed, because it's less interesting, frankly, and harder to understand, was the seeds of the property tax meddling started from the get-go. The 1901 Constitution had significant limits on property tax rates, on dollar amounts, and those limits persist today. Now, if you're in Mountain Brook, you've managed to skirt a lot of the limits. So, like Animal Farm, some pigs are more equal than others with this. But the bottom line is, for your average local area, like a referendum that Bob Blaylock wrote about years ago about Trustville, the Trustville schools, that wants to raise local property tax rates to enhance their schools, for example, you would think, and the way it should be, is that should be the business of the county commission or the mayor and the city council and the voters who would pay the tax and who would benefit from the local schools. Think again. The Constitution has to be amended. More than half of the amendments are property tax referendums, and it just keeps getting bigger. And the way it works is you've got to get not only a majority of the people in the area, you've got to get either unanimity in the House and Senate or the local Constitution Amendment Commission. Unanimity. So one squirrel legislator down that isn't even affected can block somebody's local referendum, maybe because they had a bar fight or argued about a lady or whatever. If they can't get unanimity in Montgomery, it's got to go to a statewide ballot. That's why sometimes you often see you're voting on property tax referendums in areas that you don't live in. And even if the folks in the area who are affected, who have already approved the property tax increase because they want their schools better, the whole state can tell them to shove it and we're not going to let you do it, which is what happened in Trussville a few years back. It's crazy. And this is why many frustrated local leaders, like Walt Maddox, for example, with all good intentions, just throw up their hands and say, add another penny to the sales tax, because we don't have to go through this. But it gets worse. How could it get worse? It does. In the 1970s, when there were very few African Americans in the legislature, when integrated public schools were going to be a reality, because the staving off of the mandate of Brown versus Board was coming to an end. George Wallace's administration, which in the opinion of many of us was a last gasp to thwart integration. If we're all going to go to school together, I'm not going to fund any of them worth squat, especially in the rural areas. Rammed through what is known as the Lid Bill. The Lid Bill is a complicated piece of amendment in the Constitution. But simply put, it defines the classes of property subject to the property tax, mandates the percentage of the value that goes into the base of the property tax. Now, what am I talking about? Tax is base and rate. Base is what is subject to the tax. Rate is what you apply to the base. So if you shrink the value of the property subject to any rate at all to be real small, it doesn't matter what the rate is. It's like squeezing a stone. In my article, we wanted to know what classes of property were contributing what share of the property tax. Because see, a student of mine, a former student of mine, when I was working on the project, who was a fifth-generation Alabamian, said, Hamill, it's big timber, they're robbing the state blind. And I said, do you have any proof of that? And she said, no, everyone just kind of knows. I said, well, for a scholar, I'm sure Mills would agree with me. Everybody knows is not proof or authority to cite for your proposition. Would you not agree, sir? You would. I knew he would. We worked on a civil rights case together years ago. Anyway, here's what we discovered. That Class 2 property, where the Lid Bill says a mere 20% of the fair value is in the base. Class 2 is commercial. So if you're in Birmingham, if you're in a urban area, you've got restaurants, office buildings, okay. 56% of the property tax is from Class 2. Class 3, current use homes. 10% of the value of the house being used as a home is in the base. And our home property taxes are really low, y'all. 29% of the property tax. You know, for years, the timber lobby said it was the homeowner's fault that our property taxes were so inadequate. They're not saying that anymore. Well, what about Class 1? Public utilities. Think Alabama Power. 30% of fair value in the base. They kick in 9% of the property tax. Class 4. Motor vehicles. 15% of the value is in the property tax base, accounts for 4%. What about Class 3 current use timber and agriculture? Agriculture is things like cattle farms, catfish farms, corn. Timber, we all know, are the pine trees that cover up our land. In fact, when I did my study, 71% of the land was covered up with timber, of the land mass of the state of Alabama, when I did my study, which is a huge amount. When you look at the map and see where most timber, especially the largest timber corporations that own hundreds of thousands of acres, where are they concentrated? In the Black Belt. Big timber is the substitute for king cotton. And if you look at the map, you can see it. Class 3, current use, timber and agriculture, 10% of the current use value is in the base. The current use value for timber and agriculture is a formula designed to consider productivity factors. It is a complicated formula. If you need a sleeping pill and you don't want to drug up, read footnote 85 of my article. It will do the trick. That footnote goes blow by blow how the current use formula works. And believe me, I had a very unhappy student working with me on it at that time. So you hear the drum roll? Class 3, current use, timber and agriculture contribute 2% of Alabama's property taxes. 2%. 2. So timber contributes less than 2%. I wasn't able to separate timber and agriculture. Well, how much less than 2%? Who the heck cares? You know, you want to focus on nothing or less than nothing, as Wilbur the pig said. Or as the goose said to Wilbur the pig in Charlotte's Web. And big timber is a huge part of our business. I mean, my tables show, you know, we were number 3 in wood products industry, and it's all in the tables. So we had, and the worst is that the current use formula for the base is given just as freely to the largest agribusiness as to Joe Farm with a couple hundred acres. That's right. Our little farmers are being used as human shields to protect our biggest industries from any modicum of property tax. The current use formula has its place for small farmers, but not for agribusiness. Georgia has a more sensible system. I mean, this is Georgia, not, you know, some state north of the Mason-Dixon line or one of the, you know, out the West Coast, you know, they're different than us. No, this is Georgia. This is our neighbor. Their formula for their timber is 40% of current use value for each acre up to 2,000, and then for each acre above 2,000, it flips to 40% of fair value, as an attempt to distinguish between the ability to pay between the small farmer and agribusiness. So what is the result of this? Well, the result of this is when you go into the rural counties, you know, Perry County, Wilcox County, Hale County, Sumter County, Clark County, My tables break down the acreage by county and break down the counties that are more timber dependent in terms of their industry, in terms of their income. They can't collect any modicum of tax. It doesn't matter what the rate is. If the base is this big, you can put whatever rate you want, you're still going to get nothing. And timber acres average less than $1 an acre a year in property taxes. Yes, they are robbing the state blind. And our rural school districts especially, which tend to be majority African American, by the way, are the most negatively affected. And if it wasn't for federal funding, yes, the state of Alabama gets over $2 of federal money for every dollar of federal tax paid. So much for state right independence, at least where the coffers are. If it wasn't for federal funding, which overwhelmingly concentrate on these schools in these rural areas, it would be even more pitiful than it is now. Governor Riley's plan attempted to remedy this situation by essentially copying Georgia. And the big timber lobby came after Governor Riley's plan and Governor Riley personally with fangs like nobody's business, and convinced low-income Alabamians, especially low-income whites, to vote against what would have been significantly more funding for their schools. If Governor Riley's plan had passed, the state of Alabama would be a different place, and our prisons would not be under the harsh scrutiny, justifiably so, of the Department of Justice in Washington, D.C. But Governor Riley's plan, which passed the legislature, it managed to do a bipartisan job. Maybe the last time that ever happens in the state. But it had to go through the constitutional amendment process in a way that is not only inappropriate for taxation, but pretty much guarantees that you will be stuck with the status quo, which at the moment, that's where we are. We have 5 more minutes, and rather me drone, I'll take questions, or if you want, you can get your coffee sooner. Y'all's choice. Ma'am, I saw your hand first, then I'll go to the gentleman in the front.
Are there any changes you would have made to Governor Riley's plan if it was being proposed again now?
I would have concentrated on one thing. And this is not criticizing Governor Riley. I have nothing but respect for what he tried to do. But when you have more stuff in any referendum, you have more opportunity for the evil false advertisers to do their work. And if I was going to go to battle, because I hate this big timber thing, all roads of the injustice of this state lead back to Alpha. All roads. I would go after them and blow the lid bill away. And what would I do with the revenue? I would get rid of the sales tax on groceries and lower the sales tax, put a cap on it. No more than 4%, no groceries. And then you could possibly, educating voters is hard, especially since most voters aren't thinking, they're reacting emotionally. So the message has to be emotional. But if you could convince voters, and I would leave the current use for the small farm, and I would do a study to see where the cutoff was, and really start with just agribusiness and say, okay, we're going to make agribusiness pay their fair share of property tax more aligned with other business, and we're going to get rid of all this sales tax and have the two. That's just off the top of my head. Yes, sir.
Is your article already published?
Oh yeah, it was published in in the 2002 edition of the Alabama Law Review, and somebody reprinted it as a paperback book in 2003, thinking that a law review article could sell commercially, which was probably a mistake, but that's really fun reading. And you can access all of my writings online on my faculty webpage, including this law review article. Anybody else? Are you ready for your coffee? It's 3:30, and I know y'all are tired. I'm kind of tired from doing my driving version of amending the Constitution to get here. All right, well, sir?
I'm sorry, but as an average voter, I know everybody wants to go. Should I vote for these statewide referendums in favor of the counties and municipalities, or should I vote against them as a protest of how the system operates?
That's a really excellent question, and I think a good argument can be made on both sides. And we all know what that good argument is. And you're probably asking me what I do, and the answer is I have flip-flopped. It kind of depends on the mood I'm in that day when I see these local amendments.
For the Walmatics tax or something?
Well, I didn't come down too hard on Walt. I mean, I did kind of make a snide comment. You're adding to our regressivity. And he said, yeah, I know. But I said, yeah, I know. You don't want to fool with amending the Constitution. So I think, had the sales tax, it's still being struggled with at our city council. But I would be inclined to vote against that. I cannot vote in favor of more regressivity in any form, because our taxes are so punishingly oppressive on the poorest Alabamians.
How about a use tax?
Use taxes are just the flip side of sales taxes. Instead of the sale of the property or the good or service, it's the use of it. But it all gets back to, when I'm talking about burden, it gets back. We can circle the wagon around sales and use, but it comes to the same point in the middle, which is how does it affect the burden? And if Hamill is going to purchase, let's say, a hairdryer, because that's something you buy as well as you use. The sales tax is going to hit me harder, less hard, than someone who makes much less money, because the price for the sale or the base for the use is the same and the rate is the same. And so sales and use taxes are inherently regressive. And I hear what you're saying. You can make an economic argument that use taxes are more precise, are more economically sound, and I'm not really an economist, so, I find those debates occasionally interesting, but I am more interested in terms of my work in identifying tax structures that contribute to regressivity, which is imposing a greater proportional burden on those with a smaller pie of income and wealth. That's regressivity, which no tax policy person of any respectability, even conservative ones, think regressivity is a good idea. From an economic point of view, from a moral point of view, regressivity is a terrible thing. Now, we can have a debate on progressivity versus proportionality or flatness. That raises entirely more complicated concerns for the debate, both economically and morally. And my 2002 article did not address the proportionality versus progressivity debate. A 2006 article did, but not the one I initially did for Alabama. I just condemned the regressivity and said we've got to put a stop to that, which means we've got to do something about our runaway sales taxes that apply to even groceries. It's disgusting. Coffee hounds.